Good afternoon and welcome to the afternoon session of the May docket. For those of you who are not here this morning, I'm Ross Dyer from Memphis. To my right is Judge Tom Greenholz from Chattanooga, and to my left is Judge Kyle Hickson from Knoxville. 20 minutes aside. Appellant, if you'd like to reserve time, please let us know at the beginning so the clerk can set the clock appropriately. I say 20 minutes aside. I do know the last case we have offered more time or granted your motion for more time. But with that, call the first case.
State of Tennessee versus Rex A. Martin.
Good morning, Your Honor. I'm Pat
Good morning.
McNally of the Nashville Bar. I represent the appellant Rex Martin. I'd like to reserve 3 minutes for rebuttal argument. I have made this comment several times before during seminars that I was a speaker scheduled for the after lunch slot, that it resembles the graveyard shift, working on the graveyard shift, the risk of dozing off or maybe the mind wandering somewhere else.
You don't know this panel?
Well, actually, I was going to say, I was talking about me. You know? Actually, I was going to say, I hope that I can present my client Rex Martin's issues today with vigor and for a stimulating argument today. As I said, my name is Pat McNally. I do want to reserve 3 minutes for rebuttal argument. You know, Mr. and Mrs. Martin were married in May of 2010. They lived in California before moving to Rutherford County in 2016. They'd had serious issues in California that resulted in an order of protection and a conviction for Mr. Martin regarding assaults with her. And what brings us to this case here was at trial, Mr. Martin and Mrs. Martin both testified. And they gave conflicting stories about what happened in the office of Miss Martin's, which was upstairs above the garage in their marital residence. The jury accepted Mrs. Martin's version of events, rejecting Mr. Martin's events. Now, the issues before this court today in the brief are all about sufficiency of the evidence. And I recognize the very high deferential standard when the defendant challenges the sufficiency of the evidence. I'm not going to try to reweigh Mrs. Martin and Mr. Martin's testimony today to try to persuade this court that a different verdict should have come out. What I'm going to do is address counts 1 and 2, which are the kidnapping, aggravated kidnapping charges, and count 8, which is the possession of a firearm with the intent to go armed in the commission of a dangerous felony. And I'm going to take the state's evidence. And I'm going to respect that high standard, which is that in the light most favorable to the state with the reasonable inferences in the state's favor. But I'm going to try to show to the court that there are significant legal issues here in taking the state's evidence and as to why Mr. Martin should not be convicted of aggravated kidnapping and count 8, the possession of a firearm with the intent to go armed during a dangerous felony. I'll sometimes refer to that as the armed dangerous felony, which is the classification, actually, if you look at the statute, of what they say there.
Mr. McNally, when did
Yes,
the
sir.
kidnapping start?
Right to the heart. The state's brief will say that the kidnapping started when Mr. Martin came home and took physical control of Miss Martin, restraining her up there. I would dare to say that under State versus White, that kidnapping, as found by the trial court, was incidental to the aggravated assault convictions of counts 3 and 5 and the assault conviction. There's 3, 4, and 5 are all assault convictions. So arguably, a kidnapping could have started or did start up there, but it's incidental to the convictions for the assault. And under State versus White, there would have to be some removal or confinement of the person that was not incidental to the underlying predicate felony that he was convicted of. So for purposes of review here as to whether he's guilty of count 1 and count 2 of kidnapping, our position is that you have to start when they walk down the stairs and Miss Martin started to try to walk outside with her dog, and Mr. Martin brought her back into the house and said, sit at the stool in the kitchen. And then the second removal is when he took her to the bedroom and, in a more traditional form of kidnapping, bound her with the duct tape and kept her there as he made his exit from the premises.
Was there a wide instruction that was given?
There was.
Okay.
Yeah, it was very clear. But I'm going to be very frank, pull the elephant out from under the table here. When you look at the pictures in the exhibits that were introduced to the jury, I'm not surprised that the jury would have convicted him of anything that they were given an opportunity to convict him of. I'm a little surprised that on count 4, they came down to simple assault, because that was the one where the indictment charged him with causing serious bodily or causing fear or use of a deadly weapon, to wit the knife that was up in the facts of this case are that there was a knife on him, and that there was an incident between him and Mrs. Martin upstairs when he had her down, and the knife was, according to her, put to her throat. Again, I'm not here to reweigh the evidence, but that's, it could be, that may be the one part where the jury accepted Mr. Martin's version of events, that he didn't do that.
What was the basis that the trial court had to grant the Rule 29 motion on the especially aggravated kidnapping?
It was because the trial judge looked at the events that were occurring from the time they came down the stairs and whether there was serious lack of elements for especially aggravated assault. For especially aggravated.
Which element in particular?
He was taking off he was taking away the use of a deadly weapon. There were 2 counts of there, and so he took away the use of the deadly weapon on those. So, which brought us back down to the aggravated kidnapping. And count 1 was aggravated kidnapping with took away the use of a deadly weapon on both of them, which left us on count 1 with possession of a deadly weapon or threat of a deadly weapon, or count 2, which was serious bodily injury.
Do you attribute any significance to the trial court's granting of the Rule 29 motion?
Yes, I do.
What is that?
That is that the kidnapping that's a circumstantial evidence to evaluate whether there's sufficient evidence for the aggravated kidnapping begins after they get off the sofa together and walk down the stairs.
Do you think that amounts to a judicial finding that that's what happened? Or could the jury have found that the kidnapping started earlier?
I'll think about that for a moment. I think that's a judicial finding that the factors for determination of sufficiency of the evidence of count 1 and count 2, the aggravated kidnapping, begins when they start walking down the stairs. So, actually, I would say they walked down the stairs mutually. There was no forcing her down the stairs or anything. She walked down the stairs and was getting ready to exit the marital residence to try to get to the neighbors. And when she got outside with her dog in her arms, I think that's when the kidnapping begins, because he's making her come back in the house and sit on the stool in the kitchen.
And you think the Rule 29, the ruling on the Rule 29 motion is essentially a judicial finding that there was no kidnapping, or there could not have been a kidnapping before that time because of white issues?
Correct,
Okay.
Correct. Though I will say, I wouldn't be exclusive that there was no kidnapping. I will say that there was maybe a confinement or of her physically with him sitting on or holding her down and everything.
Right.
But for purposes of determining whether count 1 and count 2 have sufficient evidence, it begins once outside when he makes her come back inside and sit down on the stool.
Okay.
I hope that made sense.
White doesn't preclude just completely that you can't have a kidnapping and an assault at the same time.
Correct. And
Okay.
I think I was trying to address that with the judge's question about whether
Yeah. And so if the state's theory, as you said, is that the kidnapping began when he entered the office, I was a little confused about whether the office was upstairs, downstairs, but anyway, when he entered the office and made threats towards her, the kidnapping, the confinement began at that point. There was an assault that occurred at some point there, and then the kidnapping, which is a continuing offense, continued once they went downstairs and she tried to, the kidnapping occurred throughout the entire process, and there happened to be an assault that took place during that process.
Let me address first the geographical setup of the house, or the layout of the house. The office is above the garage.
Okay.
And there are stairs from the first floor up to the garage. Now, what's confusing is in the cross-examination of Mr. Martin, who said, I thought I was going to be drugged down the stairs, there's a short 3 steps that go from that office up to the landing that then takes you to the stairs that go down to the first floor, if that makes sense. Okay.
Okay.
Now, I would slightly disagree with Your Honor, please, with all due respect. The confinement in the office, when he is on top, when Mr. Martin's on top of her, beating her, that is an assault. And any confinement there is incidental to the assault. And that's what White says can't be a kidnapping.
Right, but what I'm saying is one, you agree with me, kidnapping is a continuing offense. It's not just, it doesn't take place in 1 second, so to speak, it's a continuing offense.
State versus Lakes
Right.
clearly says that.
So if, in my hypothetical, someone comes into the house and restrains you, let's say for 5 minutes, 10 minutes, an hour, whatever the case may be, then after that time period, beat you up, or if it's an assault case, rape, if it's a rape case, whatever, and then they continue to hold you for 3 more days, you still have a kidnapping that started at the beginning of this that was continuing all the way through, that there just happened to be a secondary crime that occurred during the kidnapping, and that's not a White problem, is it?
No, because you started with the kidnapping.
Well, that's what, and so that's what,
But-
that's, is not the state's theory here, is that when he went into the office, whether it's upstairs, downstairs, or around the corner, when he went into the office and they got into a verbal altercation and I think maybe even made a threat towards her, that the confinement began at that point, continued all the way through however many hours this was, but that there was, at some point in time, while they were still up in the office, an assault that took place. That's the state's theory.
But
Correct?
There was no confinement until he began to assault Miss
Well, that's
Martin.
that's your position. I think what I'm asking is the state's position not that the confinement started when he came up to the office and they began their altercation, verbal altercation, and some threats were made, that's where the confinement began. Then there was an assault and the confinement continued.
But let me factually speaking, what happened was he comes up there. He, according to Miss Martin, he brushes off things off her desk and he sits down on the desk. And then they begin to argue. And he takes her glasses off. But there's no confinement. She's free to move. She's free to go about. In fact, at one point, she thinks he's leaning. She takes her glasses back. He takes them off again. And she says in her testimony, I thought he was leaning forward to kiss me. And then there's the grab and putting her down on the floor. And that's when your confinement starts. But what White holds is that you can't be convicted of a kidnapping while you're being confined during that assault.
No, but
in your-
and again, obviously I've mistaken about the facts a little bit. But my point is, I don't disagree with you, but I can start the kidnapping, have an intervening crime, and continue the kidnapping and be convicted of both kidnapping and the intervening crime.
Because there started a kidnapping, yeah. And I see Your Honor's point, but what I'm saying here is that
That's not the facts of this
you have,
case.
the facts here in this case is, they were even saying things like, get your SHIT and leave, there was back and forth, and then it's at one point, it becomes a confinement. What I was getting to about whether it's an aggravated kidnapping or not because of possession of firearms and or of firearms or threat of use of a deadly weapon. Whether it's possession of a deadly weapon and use of or threat of a deadly weapon. The only thing that here in this case is it has to be by constructive possession. The mere presence of, I'll concede, there are knives found in the house. There's a knife that Mr. Martin had on him when he came upstairs. There was a knife found in the bedroom that Miss Martin used to cut herself free.
There are weapons found in his car.
Yeah, and there were firearms. The firearms were found in his vehicle. But none of these events about the kidnapping ever occurred near the vehicle or outside of the vehicle or outside by the vehicle. And there has to be more. There has to be an intent for the person to exercise dominion and control over the deadly weapon before there can be constructive possession. And nothing in the facts of this particular case demonstrate that Mr. Martin was attempting to exercise dominion or control over these knives other than the events that occurred upstairs with the knife that he was supposed to have held to her throat.
He was arrested and had the presence of 3 knives on him. Is that right?
He did.
Okay. And he had a knife earlier during the assault.
Upstairs, correct.
I guess I'm getting upstairs and downstairs mixed up too. I thought it was downstairs, but that's okay.
No,
I think you've explained it with the steps going down, but so he has a knife during the assault, holds it to her throat. I thought the testimony is that he wore the knife around his neck.
He did.
Is that right? Is there testimony that he rid himself of the knife, or was he carrying the knife around his neck during the entire occasion?
No, it was lost upstairs during the assault.
Okay, all right, so he's arrested and has 3 knives on him. Why isn't that possession of a deadly weapon
There's
during the
nothing-
course of a kidnapping?
I was going to say that there's nothing in the proof that shows that he was exercising dominion or control during the course of the kidnappings downstairs that puts him in possession of those knives.
I mean, the kidnapping statute, as I understand it, requires just possession. And in fact, the possession of the knife could be in his pocket and the victim wouldn't even have to know that it's there. And yet it still would be sufficient for conviction.
But
So why is that not this case?
Because there was no proof that he possessed those 3 knives while he was inside the house. There's evidence that he binds her and puts her into the bedroom and then leaves. Or actually, he's around the house for about 20 minutes and then leaves. And he leaves in his vehicle and then comes back 50 minutes or so later. And at that time, when he comes back, the police are there and everything. He goes into the garage, and then the police arrive. And when he comes out, he's holding the key fob to another vehicle.
So the kidnapping ends when he's arrested?
I guess the kidnapping ends
Because
once
at
the
that point,
police
she's
go in and
released,
rescue
right?
her.
At that
Correct.
point, she's released. At the time that the kidnapping
And
ends.
can I add one other fact in there? Interestingly, the only knife that was ever possessed or anyone exercised dominion or control over the knife was when Miss Martin got up. After Mr. Martin left, Miss Martin gets up, and she knows that he has a knife somewhere, and so she goes and finds one. And she uses it to try to cut her bindings loose, and then she uses it to actually pry the door open. And she's about to make exit when she hears another vehicle pull up. I suspect it's either Mr. Martin who's going to the garage or it's the police at that time. But she then goes back into the bed and lays down, and then the police come through that door.
So at the time that the kidnapping is ended and the victim is released, at that point, the defendant is armed with 3 knives, though, right?
I wouldn't say he was armed, Your Honor, because
He's in possession, he's in
in
actual
possession of-
physical
yes.
possession of 3 knives?
yes.
And that's not sufficient to sustain the conviction?
I would argue that it's not for what occurred when he was inside the house and Miss Martin was being under kidnapping.
Even though it's a continuing offense?
Correct.
Do you think, is your theory that the defendant has to possess the deadly weapon throughout the course of the kidnapping? Or that he could possess it at some points during the kidnapping alone?
No, the case law, I think State versus Fay says that you can take possession of it later and then
Right.
have it. Can I address real quickly one thing on count 8? I'll leave to my argument in the brief about why there's no bodily injury to sustain count 2 as aggravated assault. But on count 8, which is, and I'll go into my rebuttal time here in a moment. Count 8 is the possession of a firearm with the intent to go armed during a dangerous felony. And the 3 elements of that are 1, you got to possess a firearm. 2, you have to do it with the intent to go armed. And 3, you have to be during a dangerous felony. If the court accepts my arguments on count 1 and count 2, the kidnapping falls to false imprisonment, which is not a dangerous felony under the definition of the statute. But it also has to be during the commission of the kidnapping. And I've made my argument here that the firearms, as Officer Kelsey testified, the firearms were taken out of the bed of the pickup truck, and they were eventually laid out on the ground. They were not possessed during the course of the kidnapping, though I respect Your Honor's argument about the continuing nature of kidnapping. But here's the other clincher here. And I checked carefully on this, the intent to go armed. And I thought about, what is it, how do we determine the intent, the purposeful intent to go armed? Well, usually a person has a firearm, go armed with a firearm. They have a firearm, they have ammunition, and they have the gun loaded most of the time. Now, granted, I know there's a case out there that says that an unloaded gun that's pointed at a police officer and pulled the trigger can constitute a deadly weapon, or can be constituted as being going armed. But here, I looked carefully. There's no ammunition. No ammunition taken out of the vehicle. No ammunition seized at the home. Mr. Martin didn't have any ammunition for any of the firearms. Now, I know it's not a statutory requirement to have ammunition, but it's certainly probative on his intent. And whether that intent was to disperse, to get rid of the firearms, or to go armed, it's relevant to that inquiry. And I would submit that with no ammunition found by anybody, that is an intent that he was not going to go armed. and that count in particular ought to fail. Thank you, judges. Appreciate your patience.
Thank you.
Thank you.
Good afternoon. May it please the court, Ben Ball on behalf of the state. I'd like to start out by talking about the trial court's partial granting of the motion for judgment of acquittal. And that's what it was. This was not a judicial finding demarcating different periods of confinement. This was finding that there was essentially an element missing from especially aggravated kidnapping, a finding that the state very much disagrees with. I think the evidence
What was the element that the court found did not exist?
I believe it was the serious bodily injury, as I understand it, which honestly doesn't make a lot of sense to me. Frankly, the trial court's ruling here doesn't make a lot of sense, but the effect of the trial court ruling is that it is granting a judgment of acquittal as to especially aggravated kidnapping while preserving aggravated kidnapping for the jury. And the jury is charged on aggravated kidnapping, and they're charged with a White instruction. They're not charged about what specific periods of confinement are. There was one continuous period of confinement here, and I'll briefly go over the facts of this case for your honors. Feel free to cut me off, but essentially what we have here is defendant and the victim, his wife, are fighting via text message over finances. And this is going on while Mrs. Martin is trying to work. She works remotely, she works in their bonus room, and she's working a late shift. At some point this fight escalates, and she tells him essentially, you know what, come home, when you come home, get your stuff, pack it up, get your Harley, get your car, and get out. He does come home unexpectedly and confronts her.
So when does the kidnapping begin?
The kidnapping begins when he lays hands upon her. When he deprives her of her liberty. At the very least, it certainly begins when he has his hands around her neck and has her pinned to the floor. She cannot go anywhere, and at no point is she not constrained of her liberty after this point. She does make a run for it. The defendant sees it coming and cuts it off. So he chokes her, he hits her, and you'll see the pictures. He hits her quite a bit, quite viciously.
So the assault had already started by that time, though, is that right?
Right, he struck her. There was an exchange. I don't think she expected him to assault her initially.
Sure.
And
And at one point he's on her, at another point he picks her up and puts her in a chair?
he does.
Is that still part of the assault?
He has hands on her when he puts her in the chair. I don't think it really matters, but she's confined. She certainly is not free to leave at that point. And we certainly have enough for the assault before that.
True, and it's not being vigorously argued today on appeal, though it is in the brief, of course.
But so he strikes her, he chokes her. This knife is hanging down. He's got this, I think it's described sort of an engineer's knife, which is consistent with what he does for his job. It's hanging down around his neck, and she sort of makes a grab for it. He then takes it and holds it to her throat. The knife is then sort of lost in the shuffle at this point. He continues to choke her and strike her until he becomes tired and goes and sits down. They do leave the bonus room, and she makes a ploy of taking their small dog out. The dog is older. I've been through this with the dog before. We had to physically carry the dog down the steps to take it out to go to the bathroom. That's not where she's going. She's trying to escape. He catches onto it and keeps that from happening. And he explains to her, you're not leaving. I'm not taking you to the emergency room. We're not reporting this. You're not leaving, and I guess I'm going to have to tie you up. He takes her upstairs. He binds her with duct tape. He puts her on their adjustable bed. He puts it upright. He takes tools. He takes the handle off the doorknob with the tools, and he leaves her there. She is able to get off the bed and go to the armoire where she knows there is a knife because the defendant has knives kept all over the home. She's unable to cut herself free. She is able to pry open the bedroom door with this knife. She gets back to the bonus room. Her phone is now missing from where it was, but she has what I understand to be a phone without service. She uses this phone. She puts it on the Wi-Fi. She broadcasts to a Bluetooth speaker. This is the music she plays while she's working at home. But of course, even a deactivated phone can call 911. And that's what she does. While she's talking to 911, he returns. Fortunately, the police also returned at this time. He does have knives on his person. In his car, my friend on the other side alluded to him having firearms. He had a sort of a melange of modern and archaic weaponry. He had assault rifle, he had long guns, he had a katana, he had a crossbow, and he had a tomahawk, amongst other weapons. Just a strange assortment of weapons.
So General, can I ask you, let's assume, just for sake of argument, that the kidnapping clearly starts, I know the state disagrees with the position, that the kidnapping clearly starts at the point where the defendant confines her after she's trying to take the dog out. Is there evidence of serious bodily injury occurring in the kidnapping after that point?
I would have to acknowledge the serious bodily injury had happened before, and there is some
So it's
some
all
additional
before
injury.
that, right? So if the kidnapping occurs at that point, then aggravated kidnapping, I guess, is out by way of serious bodily injury. So to sustain the verdict, the court would have to find, or the jury would have to find, that the kidnapping started earlier than that, right?
That's right, and the kidnapping did start earlier than that. And
What about with the deadly weapon? So if the kidnapping starts at the point in time where she was trying to take the dog out, it starts there. What evidence do we have that he's possessing a deadly weapon during that time?
so during that time, if it started there, and again, I would
And
assume
I know
it did
you
not.
disagree with this. I'm trying to figure out how far the argument goes. That's all I'm doing. So
And it's
where's the
much
deadly
it's
weapon?
much easier with the deadly weapon for the state on that, because there are deadly weapons aplenty, and they pop up well after the initial assault. There is evidence at the time he tells her he's going to tie her up. We have a photograph with police discovered in the kitchen where he told her this. There is a knife.
Okay, so that's a kitchen knife sitting on the counter.
I believe it's a sheathed knife,
Okay,
if I
all right,
recall. So
okay,
I don't think it's
all
a kitchen knife. This is, I mean, obviously, a kitchen knife can be a deadly weapon.
It can be.
But this is not, my understanding is this is not a kitchen knife. I believe it was described as being in a sheath.
Okay. What else?
He also had the knives on his person. And then the kidnapping is still,
When he's arrested?
when he's arrested, he also has, possession of these weapons there in his trunk, and there's quite a few weapons. So I think that one's easier for the state, but I don't think we have to go there, because when we're talking about White, what White says is that due process essentially requires a finder of fact when you have an offense that has inherent in it some form of confinement. Obviously an assault, a robbery, something like that. The confinement cannot be essentially incidental. And I think the sort of the classic example we see in the jurisprudence is the robbery scenario, where say you have a fast food restaurant and an assailant comes in, he holds the cashiers at gunpoint until they hand over the money and the counter, and then he leaves. That's not a kidnapping, because the confinement is essentially incidental. But if he takes the cashiers after he has the money, and he takes them back to the back office, and he ties them up, and he locks them in the office, well, that's not essentially incidental. And it's not, White doesn't say that the jury then, or the finder of fact, draws a line of demarcation. There's one period of confinement. And so from the time here that the defendant initially restrains the victim of her liberty to the time that restraint ends is the entire period.
So you have a situation here where it looks like it starts off as an assault, develops into a kidnapping as assault is continuing to occur, and then I guess further develops from that into a restraint on liberty where assaults are not occurring. Is that what's going on here?
I'm not sure if I would distinguish it that same way, because I think what we have here is the assault has with it an inherent confinement aspect.
That's right.
So the confinement begins the moment the assault begins. And that confinement applies all the way through. So the kidnapping and the
So could the jury then find the defendant guilty both of the kidnapping and the assault there at moment one?
Yes. Yes, and
How is that?
And the jury was charged in that way. I mean, they were charged with White instruction. They weren't, despite the trial court's earlier ruling on the motion for judgment acquittal, which is not a model of clarity, it didn't change what the jury was tasked with determining. And it certainly didn't instruct them that there were different periods of confinement. And the jury, as finder of fact, was entitled here to find there was a single period of confinement, that this period of confinement was not purely incidental to this brutal assault that took place on the victim. And that's what the jury did. as was its prerogative, and this court should not overturn that jury's finding. As far as the other issues raised by the defendant, I think they all sort of rise and fall on this same thing, the question of this period of confinement. And should this court determine, as it should, that the period of confinement was continuous from the moment the assault began until the police freed her, I think these issues also fail. So I would defer to my brief on those unless this court has any questions.
Your friend on the other side raised the issue about whether there's sufficient proof for a jury to find that the defendant had the intent to go armed. What I understood your friend to say was that the weapons were not loaded, they were not actually used during the kidnapping, they weren't used offensively. They're there, but they're not used offensively. Typically, those are the factors that we would look to see whether there's an intent to go armed present. What's the state's best argument?
I would respond that one of those weapons was used offensively. The knife around his neck that he held to her throat.
Okay.
And
Once
I
again,
think
going back to the earlier,
and again, this court can go back to that because the jury did. That is included in the period of confinement. But also there were other weapons other than just unloaded guns. There were numerous knives and things that did not require ammunition.
what about with respect to the firearm, though? And so I thought that the issue that he was raising was solely with respect to the possession of the firearm.
I think that there was, as far as the firearm, the jury had enough, circumstantial evidence
Like what?
based on his behavior, especially he's confined her. He's told her that she's not going anywhere. He's left the home and he's returned with the trunk.
Well, if the firearms are unloaded, if the firearms are in the trunk of the car, if the firearms themselves, he's not using them actually using them during the course of the kidnapping, if they're not used offensively in any way, what's the evidence that the jury could rely upon to find that he has the intent to go armed with the firearm?
It's the same with any intent. It's always circumstantial, with intent. And while we don't have the weapons being loaded, we do have the circumstances under which he returns to the home with these weapons, and I think that is enough from which the jury could reach that conclusion.
How is that different from simple possession?
It's different from simple possession given the circumstances of the ongoing kidnapping and his return to the home with these weapons.
Logically extended, it sounds like that anytime I'm possessing a weapon during the commission of a crime, I'm necessarily having the intent to go armed. Is that what you're saying?
That's not what I'm saying. I would say with these particular facts and the sequence in which they occurred, this was highly indicative of intent to go armed.
Because otherwise, the offense would not be possession of a firearm with the intent to go armed during the commission of a dangerous felony. It would simply be possession of a firearm during the commission of a dangerous felony, right?
Right.
Can you help me again with the circumstantial evidence? I don't see it clearly.
Okay. So what we have here is not just a defendant who was initially armed, but a defendant who, having threatened his wife and explained to her that she is not leaving this house, has gone out of the home and returned with more weapons in his trunk. That's what we have here. And I would suggest to this court that is plenty from which the jury could reach this conclusion. And if there are no further questions, I would urge this court to affirm the judgment of the trial court here.
Thank you, counsel.
Thank you, Your Honors.
All right.
I just want to make sure the facts are very clear in this case because this is so fact-dependent when you're looking at challenging sufficiency of the evidence. Mr. Martin was indicted on especially aggravated kidnapping in count 1 by use of a deadly weapon, and in count 2, especially aggravated kidnapping causing serious bodily injury. The trial court was very clear in its findings that the court finds that the confinement was incidental to the aggravated assault, and there's no proof that the defendant used a deadly weapon for subsequent kidnapping or false imprisonment. That was the JOA on count 1. On count 2, with the same thing, the court found that there was no serious bodily injury as a result of the kidnapping once they went downstairs. The other point I want to bring up is that there was a suggestion that Mr. Martin carried Mrs. Martin to the sofa in the office. No, she testifies herself that she actually walked over to that sofa. They sat down. She as a ploy, said, "I love you. Let's go to bed. We'll talk about this later." I understand it was a ploy, but there was no confinement or holding her against her will at that point there. And then they walked down the stairs together, and it wasn't until they were outside when she was going to the neighbors that he made her come back in.
Let me ask you this.
Yes, sir.
I recognize we can't turn around and convict your client of especially aggravated kidnapping, but are we bound in any way by this trial court's determination of when things began and when things ended, and therefore his determination that there couldn't be an especially aggravated kidnapping? I mean, it's a legal question versus a factual question, is it not?
Well, facts to the law, yes. It's an application of facts to the law for a legal conclusion, correct?
Right. I mean, so we're not bound by this determination by the trial court that there can't be an especially aggravated kidnapping because here's when one started and the other one started and here's when one ended, right?
Correct. This court is not bound by the trial court's findings or conclusions of law, and I've often come up here to suggest that. And the other thing I want to point out was just that Ms. Martin, and again, I'm not weighing the evidence of either one, but Ms. Martin testified that it was regarding the knife that was upstairs in the office in Mr. Martin's hand. He raised it in his hand. He was holding the knife right there, and it was just like lightning a bolt hit his hand. It didn't really fall from his hand. He didn't throw it. It just dropped. And I want to make sure we were clear about the facts on that. And I don't know what to make of the fact that the jury, count 4 of this indictment was charging Mr. Martin with aggravated assault by the use or display of a deadly weapon upstairs in the office. And if you look at the verdict form, the jury comes back and found simple assault. They did not find that there was a deadly weapon used during that aggravated assault. So even if I took the state's theory that the knife up in the office somehow is part of an ongoing kidnapping, the jury, which I would respectfully say the court probably is bound, should respect that since they're the finder of the facts, the jury found there was no deadly weapon upstairs in the office. Thank you for your time.
Thank you, Mr. Brown.
Thank you. Call the next case, please.
State of Tennessee versus Brendan T. Negron.